Thank you all for joining. As I mentioned just at the beginning, I'm here at the moment with Dorothee from SKW Schwarz in Germany and Terrell from Foley in the US. Maarten from Kennedy Van der Laan in the Netherlands is, I think, with us in spirit and can hear what's going on, but at the moment has some technical difficulties. So when he joins, he will participate as well. The title of today's webinar is Managing International Intellectual Property Disputes. And really, it's something that we wanted to do primarily, I think, so that we could talk at quite a high level about some of the differences that you might find if you're running an intellectual property dispute in either Germany, the US, or the Netherlands. So my practice is in the UK, and I would not intend to talk too much on my side about the UK position, but really rather only be using the UK position as a point of contrast or to show any kind of primary sort of points of difference between the UK position, the German, the US, and hopefully the position in the Netherlands as well if we get there. So what I would like to do at the beginning is allow the speakers an opportunity to introduce themselves. I'll do the same. My name's Iain Rutherford. I head up the IP/IT disputes team at Brodies in Edinburgh. We practice UK-wide, but over the last few years, we've had a fair bit of experience of working with clients who have a global presence and therefore have worked with clients with firms in other jurisdictions where those clients are looking to protect their intellectual property rights in those other jurisdictions. And it's off the back of that that we thought it would be useful to share a bit of that insight, because I think one of the main dangers that you have is that you assume the position in one jurisdiction is going to be similar to the position in your home jurisdiction and then find out often sometimes a bit late in the day that it's not quite how you expected it to be. So it's to look to try and address some of those issues. I'm not intending that we're going to get into really detailed discussions about procedural aspects, etc., etc. I don't think that would work very well. The idea is that we'll keep this at quite a high level. So the first question I wanted to kind of put to the panel was really one just about what basic IP protection is available in the respective jurisdictions. And I think we can probably take it as read that trademark, patent, copyright protection is available to some extent, but it would be helpful to confirm that, but also to explain what other perhaps slightly more quirky protections might be available. And I'm thinking in the UK of things like unregistered trademark, or what we would call passing off protection, trade secrets, confidential information. So Dorothee, if I could come to you first, if you could kind of introduce yourself and then just elaborate a bit about what the typical kind of IP protection framework looks like in Germany.
Yes, thank you, Iain. Hello, everybody. My name is Dorothee Altenburg. As you may see, I'm in Munich, the capital of IP in Germany, I'd say. I am practicing IP for almost 30 years now. I don't look like that, I know, but doing mostly soft IP, but also patent, unfair competition rights, trademark rights. We do both prosecution and litigation, not only on a national scale, but also on a EU-wide and international global scale. So we manage global trademark portfolios. We see a lot of litigation also between clients coming from different countries. So that's a little bit of my background. As to your question, Iain, besides the ordinary IP rights, we have quite a good level of protection also for unregistered rights, although we do not have the passing off as you have it in the UK. We have, for example, the Act of Trade Secrets, which comes from the directive, of course. We have unregistered trademark rights because of secondary meaning, or notorious trademark rights, also deriving from the Paris Convention. We have trade names which are protected also under the Copyright Act. not being related necessarily to a registration of a company, but merely by use of the trade name. We have a very special legal figure which we call title rights, which exists, as far as I know, only in Germany and maybe Austria. This is pertaining to work titles, such as titles for books, films, but it may be also relate to events, to software, and which is merely based on actual use. And this can often help, although the scope is different, as for example, compared to trademarks, but this can often help also against registered trademark or registered rights. Thank you.
Thank you. No, that's interesting. So it's actually just what the event or the book, the name of the product or the event it attaches. There's a particular protection that attaches to that.
Yeah, it's not a product. It must be a work.
Right.
And this is, of course, something to be defined. And this would take too long maybe here to explain, but it is.
That's the danger. If somebody says something that becomes quite interesting, I'll have to stop you talking about it.
We can talk about this about hours.
That's fine. So thank you, Dorothee. And Terrell, really the same question to you. You could just kind of introduce yourself and then just give an overview, really. And I appreciate you have a substantive task, given that I'm looking for you to speak about the entirety of the United States of America. So do your best. Do your best.
Sure. Thank you. So again, I'm Terrell Miller. I am an intellectual property attorney with Foley Lardner. We have about 24 offices across the U.S. And one in Mexico. And we're a full service law firm. I myself have been practicing intellectual property for about 20 years. I do trademarks, patents, contract, and then the substantial portion of my work is intellectual property litigation. And that covers everything from copyright, where I recently just was successful in a 7-day copyright infringement trial in federal court. I've got another trade secret trial coming up here in the next month. So we pretty much cover all aspects of those forms of intellectual property with respect to litigation. And then, of course, when we talk about the types of intellectual property registrations available, of course, that's going to include your patents and your design patents, your federally registered trademarks and your copyrights. We do have common law protection for trademarks. I know Dorothee talked about that as well. It's a secondary meaning standard. We have the same, very similar situation here. As far as trade secrets go, there's no official registration procedure for something like that, but we do have common law trade secret acts, and then federal. Recently, within the last few years, the Federal Trade Secret Act is available in the United States. And what that really does is the United States has a two-tier court system. We have state courts within each, within each U.S. state, but then there's also federal courts that can be, you can have jurisdiction in those federal courts if there are federal questions or what we call kind of diverse parties of where their residency is, citizenship is. But you can also get there with the federal question. So the Federal Trade Secret Act now allows you to get trade secret cases more easily into federal court because it gives you federal jurisdiction in that context. So really, a lot of statutes are going to help you get into federal court or to help you seek enforcement of your various forms of intellectual property. But as far as registrations go, it's pretty much the same basics that most all of you have: the patents, the trademarks, and the copyrights.
Thank you. That's really helpful. And Maarten, are you with us?
I hope so, Ian. I hope you can hear me.
We can hear you, we can see you, and you're wearing a much snazzier set of headphones than you were when you started. So it's perfect timing, perfect timing.
Very good.
So I'm not sure if you got I think you know the introduction anyway, but really if you could just summarize the position in the Netherlands, but also just say a bit about yourself and your firm.
Yes, thank you very much. And I'm very happy to join, after all, 5 minutes late, but please excuse me. I'm Maarten Schut. I'm based in the Netherlands at Kennedy Van der Laan in Amsterdam. And that's a firm that's been around for like 25 years. And I've been there for about 20 years. And we do, it's a full service firm, but we do a lot of IP, a lot of tech, media, TMT work. So it's very much focused on that. I'm part of the IP department, and I litigate a lot about patents, trademark, copyright, etc. So that's my firm. And well, speaking about the Netherlands, I think I missed your question, but I think it was like, what kind of protection do we have apart from the regular ones, right? That's the idea. And well, we have, of course, the patents and trademarks and copyright basis for claims. I think the big difference perhaps would be that we don't have anything like trade dress, which in the UK. We have no unregistered trademarks, so that's all lacking. What we do have, and I'm not completely sure about the other countries, but we do have something called slavish imitation, which is the idea is that you are basically free to copy anything that's not protected by an IP right up to a certain level. And when you go too far, let's put it that way, and it's completely the same, you could have avoided confusion, and there's really no reason why you did it this way. That's a kind of like rest category, which we use in Holland alongside copyright. So that's a kind of extra basis for a claim. That's peculiar. And I think on the trade secret side, that will be a bit similar for European countries. We have a Trade Secrets Act since a couple of years. That's pretty new for us. And interesting, I must say, because we didn't know that much about trade secret protection before. That was a kind of general concept under civil law.
Oh, I think we lost you temporarily, but you're back. But I think
I hope that was short.
Yeah, that was perfect. That's perfect. Well, thank you very much.
Sorry, go ahead.
No, that's great. But if we move on to talk about moving into some slightly more procedural aspects, and really I wanted to talk about pre-action at this stage. It used to be in Scotland anyway that there was quite a lot of enthusiasm for going straight into court and trying to obtain interim injunctive relief without really the need for very much notice at all. And that's because we have a peculiar system of lodging things called caveats with the court, where the court will give a party notice if somebody attempts to obtain some kind of interim order against them. That's peculiar to Scotland. But even in Scotland, we've kind of moved away from that now, and generally the expected practice in the UK would be that before legal proceedings or IP litigation is launched, there would have been some kind of pre-action correspondence, whether it was seeking undertakings or at least putting a party on notice and giving them an opportunity to take steps to remedy whatever the infringement was before legal proceedings were launched. And if that's not complied with, if those protocols are not complied with, then there could be cost sanctions against the party if they haven't gone down that road. So really, it's probably quite a brief question, but I just wanted to check, and I can maybe start with you, Terrell. What's the kind of US court's approach to pre-action conduct? Is there an expectation or a need to engage, or could a party go straight into court and look to obtain some kind of relief without notice?
Yeah, generally a party can go straight into court. The only time that is maybe a little different is if there's a contractual provision, maybe two parties to a contract and they're about to have a dispute in a contract, and there's a pre-suit mediation provision, an attempt to informally resolve it. But outside of that, no, parties can typically go straight to court. Even when you have a contract with a pre-suit mediation provision, there's usually language in those contracts that allow you to go for an injunction prior to even seeking the mediation.
And that would be, there would be no need to write at all to say this is what we're going to do. You could just go straight into court and try and obtain that order.
That's correct. Now, that's not the norm. I mean, typically you're going to get a demand letter. There's typically going to be some exchange, but parties are hesitant to do that in the US because you can do what's called a declaratory judgment, where if you threaten somebody with IP infringement, they can then file first and try to get a declaration of non-infringement, and they then get to pick which court jurisdiction that they want to be in. And so there's a little bit of forum shopping that you have. So that kind of counters against giving demand letters where you're pretty confident you're going to end up in litigation, because it might take away the plaintiff's advantage of choosing the forum for the dispute.
Mm-hmm. It's interesting. Makes sense. Certainly makes sense in your jurisdiction that you would not look to go down that road. It's very much the opposite direction to the way that things go in the UK, where there's quite there is, as I say, really a very heavy expectation that there'll be some kind of pre-action engagement, and it can kind of count against you if there isn't that. But that's interesting. But it actually makes sense in that context. And Dorothee, what's the position in Germany?
I think one has to differentiate a little bit between the interim proceedings and the ordinary court proceedings.
Yep.
The ordinary court proceedings, it's, I think, similar as in the UK. You can go immediately, but if the other side acknowledges the claim immediately, you will have to bear all costs. In interim proceedings, until quite recently, we had the possibility of ex parte proceedings as well. But a couple of years ago, we had a decision, or I don't know, even several decisions by the Federal Constitutional Court saying that there should be a kind of equality of arms and no, in order to avoid some kind of secret procedures, that the defendant must have a kind of opportunity to be heard either by a warning letter in advance, or by an oral hearing, or by lodging a so-called protective writ, which is also, I don't know whether you have that in the UK. So that is a possibility if you do know, or if you have an idea that somebody is going to attack you with an interim injunction, you can file with a central registry with all courts a kind of protective writ.
Yeah, I think that sounds similar to what I was mentioning, which would be the Scottish caveat system, where you will be told by the court if somebody is trying to obtain an interim order against you.
Yeah. So it's not an obligation to do it, but it's a kind of, we say Obliegenheit, which you hear it's obligation. Obliegenheit is quite similar, but it's not the same. So it's a kind of duty which may result in some negative consequences if you don't do it, but it's still possible, especially in very special cases where it is clear that if the opposite side is heard before, or if even a warning letter is sent out, it has to be anticipated that huge damage will happen and cannot be resolved otherwise than by ex parte proceedings.
Yeah, so no, that makes sense. And Maarten, in the Netherlands, how does it work in terms of pre-action conduct?
Yeah, I think it's still a bit different from each of the other stories, so it's different in every country.
That's good. That's good.
I'm thinking about it because there's a kind of more like an implicit presumption that you will write a warning letter first. It's not a real hard rule, but if you don't do it, you will run into a lot of trouble when you get to court, because the other party may react in a certain way and you don't know what the response will be, what your claim should be. You may have to pay the cost. So it's very unwise, I would say, unless there's a very specific scenario where you have, for example, infringing goods and you want to seize them. That's the exception. But if you have a normal IP discussion, I would always send a warning letter in Holland. And we are not that afraid of forum shopping or of the US example, where where the other party will take the first strike, so to speak, because that hardly ever happens. If you are the IP owner, you will be the one to go to court, and there's not much reason to do so for the other party, unless, again, there's an exceptional scenario where you send out tens of letters to clients, for example, customers of the infringer, and there's a real problem with that. Yeah. But I know, and it's a question perhaps for you, Iain. I know that in the UK you have to be super careful with sending out, for example, letters to customers of an infringer, and I think that's a big difference. That we are a bit more relaxed, perhaps, about that on the continent.
That quite happily links into my next question, almost like it was sort of set up, Maarten. So that's appreciated, because it's I mean, you're right, similar to Terrell's point, and it is the next question really, because in the UK we have threats legislation, so that if an unjustified threat is made, and it does sound like there's a similarity there with the US, then the party against whom, or actually not even just the party against whom the threat is made, but third parties who might be affected by the threat, can go to court to obtain orders that the threat is unjustified and can raise their own proceedings on the back of the threat that is made. So I think that is why there is a degree of reticence, but some thought has to be taken. You certainly wouldn't automatically send out blanket letters to customers. You would be careful about attacking the supply chain, because the threats legislation doesn't apply to direct infringers. You would tend, because of that, to target the direct infringer rather than attacking the supply chain. There's a bit more kind of pause for thought there in the UK. And I think, Terrell, just coming to you, you'd obviously touched on this, but it sounds like there's similar provision in the US in terms of responding to a threat that's made of IP infringement.
Yeah, that's correct. As I mentioned, the Declaratory Judgment Act, if somebody is threatening you and you feel it's wrongful, unfortunately, that does require you to go to court. And when you go to court, unfortunately, in the US, it's very hard to recover attorney's fees absent clear contractual provisions. Many statutes, particularly in intellectual property, do have the opportunity for attorney's fees. And I don't want to necessarily, I think maybe that's a topic we'll get to later, so I don't want to dwell on that. But the point is there's not a lot of incentive for somebody to want to run off to court to necessarily clear the air on the intellectual property infringement unless the threat is pretty severe and you think there's really going to be a dispute about it. If there is some frivolous or weakness to the claims, what you typically see is when a party maybe doesn't file a declaratory judgment because they don't want to interject themselves into expensive litigation, they might wait until they're sued to see if it happens. And if they are sued, then they might counter back with a claim for what we call a motion to dismiss and then seeking sanctions for the frivolousness of the claim.
Yep.
There's even Rule 11 violations, we call it, where an attorney certifies the substance of a claim. And then if that is determined to be demonstrably weak or a thin claim, even the attorney can be sanctioned for being the representative to bring that claim.
It's making everything I've watched on Suits seem a wee bit unrealistic, which is disappointing.
A little bit.
Yeah. And Dorothee, in terms of threats, or is there any kind of sanction for bringing threats of IP infringement in Germany? If you receive a letter threatening something, is there a remedy available to the potential defendant?
Yeah, there is. So an unlawful threat, a warning letter based on an IP right, which turns out to be unjustified, would be held as an interference with the established and exercised business right. So this is a civil code provision, and so it would be give basis for injunctive relief, and if it was done by intent or even by negligence, even give a claim for damages. So what you would usually do if you are not sure if you have the matter rights, you would not formulate, which is a quite formal thing, a warning letter with a cease and desist claim, but you would rather create a sort of authorization request for example, on what basis do you feel authorized to act this way and this way, although I have these and those rights, for example.
Yep.
Yeah, this would be not regarded by the court as a clear warning letter, and then if the other side answered yes, because I have those unregistered rights, for example, then this would turn into a discussion and not give rise to this. But I have another question just before to Maarten. As you said, the warning letter is quite mandatory as I understood, in the Netherlands. Would it be the same, for example, in trade fair cases, which is very short? Term, if somebody appears there with I don't know, an infringing model or infringing trademark, also this happens quite often in Germany. So
I understand your question perfectly, Dorothee, and it's of course I was just summarizing, and we do have an ex parte procedure as well,
okay.
like in Germany. I think it's a little bit different, that it will be for those kind of circumstances, like a
Yes.
trade fair or clearly infringing goods that are
Okay.
somewhere in a
I
ship or
see.
something. So you have a real need for speed. And actually, it's interesting that it's pretty informal. You have to write a request that's very solid with your IP rights and what's happening, etc. That takes some time. But once you send it to the court, you may get a phone call from a court clerk saying, "What do you mean by this and this? And could you please explain a little bit in an email?" And then you have to send an email like, "I mean this and this," and then. So it's a very and then you might even retract it if you have the idea that you won't get it. So it's pretty riskless in a way, but they will only allow it under very clear circumstances. So it's not something we do often.
And would such communication be taken into the file? Would that
no,
be
I know in Germany that they do that, and that's very interesting to me because we don't do that in Holland. So it's
okay,
if you are the infringer, and you will never know that this happened if it isn't allowed, and if the request is allowed, it will be part of the verdict, so to speak, of the court. So they will attach the email to their decision. But it's that's again very different. And if I may, Iain, you're the leader, but can I ask Dorothee something back about Germany? I still have the impression that in Germany it's very easy to get this ex parte decision, and it's often a strategy of international firms, in my experience, that they are thinking about Europe. They don't know where to start, and that they will for sure start in Germany with an ex parte, and then extend with other actions across other countries. Is that your impression as well, or?
I think it has been reduced a little bit because of this decision, which I mentioned earlier, of the Federalist Constitutional Court, and also the decision was a consequence of these kind of correspondences between the court and the applicant. When, for example, the judge thought that the claim was not worded in the right way, and so they had this kind of discussions, and then something was changed and so on. So they really wanted to give an equality of arms, and of course there are many exceptions to that, and they're still existing. We call these, this was also a strategy to have these kind of drawer injunctions, which you obtain ex parte, put it into your drawer, and then see what happens. You have 1 month time until to notify the infringer, otherwise the decision will be lifted by the court if it is not served. So it's still a strategy, but it's not that common, I think, as it was before.
Why would you do that? Why would you obtain the order and not serve it on the infringer?
When you look what is going on, you may negotiate with the other side.
So say that we've got this.
See whether they might give in to your claims, and then if they don't, you serve it.
It's a different strategy, but no, I think that's really helpful discussion, and it does feed into really the next. I mean, we certainly in UK terms, it sounds like, again, similarly to Germany, an awful lot of IP litigation, particularly in the trademark space, will begin and end with the application for an interim injunction. And if the interim injunction is granted, then in the majority of cases, they may not go very much further beyond that. The interim injunction is granted. Maybe there's an argument about whether it will be recalled or not, but usually then there would be a negotiation, or that would just be an end to the matter. How readily available, and I'll maybe come to you first, Terrell, because I think the position in the US is different, or certainly I've found it to be slightly different to the way it is in the UK. How readily available is kind of interim injunctive relief in IP litigation? Would you view that as the primary remedy?
No, I certainly wouldn't. Injunctive relief in the United States, whether it's state or federal court, requires a showing a substantial likelihood of success on the merits, in addition to irreparable harm. And so it's a heightened standard. And there's a couple of other elements that are not worth mentioning, but But the irreparable harm and the substantial likelihood of success on the merits really weighs in favor of not getting an injunction in most IP cases. So really, outside of trade secrets, when you look at patent, for example, the court's going to look at it and say, there's really no irreparable harm here, because at the end of the day, I can likely compensate you if you win with a monetary award for your harm. So there's no need for this, shortened kind of mini trial in a court to issue an injunction to stop a party from doing something during the pendency of the actual litigation, which in the US can be 1, 2, 3 years to get through the litigation. So those injunctions are really disfavored by courts. Again, if it's a trade secret where once the cat's out of the bag, no amount of money is going to put it back in, that's the situation where you'll see a court say, okay, we're going to press pause on the risk of this intellectual property being made public, and we're going to pause that while the pendency of the litigation occurs. But really, outside of that, it's very hard to get injunctions in the US, particularly in these types of IP matters. They're just not what you typically see.
I think even on the terminology, because if I'm just thinking, I mean, your test of irreparable harm would be the equivalent of what we would call the balance of convenience. And even just on the terminology that's used there, you can see the difference, irreparable harm versus, this kind of balancing act of who's going to be more or less inconvenienced. Ours sounds very British, not very dramatic, but I think that's what we've seen before in US litigation, but I think it's a really important point of difference, that you really do need to be kind of gearing up to move towards trial in relation to IP infringement, rather than going into that thinking, oh well, if we can obtain an interim injunction, that'll be an end of the story, unless you can weave in some kind of trade secret type angle to it.
That's right, and really in patents in particular, I always mention this one. For patents, because you have to have what we call a claim construction or a Markman hearing in the US, where you have to go through and define the terminology of the claims, really define the scope. Courts just aren't going to do that in a short injunction proceeding. They're going to make you do the full discovery so the parties get the fair shake and the fair determination, the opportunity to fully present all their evidence and experts on the meaning of those claims and the scope to see if there's going to be any infringement. And courts just aren't willing to do that in an injunction proceeding, particularly where money can satisfy the harm anyway.
Yeah, okay. And Maarten, in terms of in the Netherlands, in terms of injunctive relief and IP litigation?
Yeah, I think that's very European, I would say, and not very like the US. We litigate mostly, I think, in summary proceedings in IP. But there is a special thing in Holland. I don't know about the other countries, but we have a kind of more or less formal obligation to follow up with litigation on the merits. So once you start your summary proceedings, you have to be willing, if necessary, to move on to litigation on the merits, and that might be a problem. And usually you negotiate and you have your success, and then it's all fine and no one talks about it anymore. But if you kind of forget this, the other party may strike out, so to speak, the injunction after a set time period, and then it's all open again and there's no injunction. So that's a peculiarity, I would say. And otherwise, the courts are very much judging the case on almost like as if it was a merits case. So they simply look at all the evidence, have the same more or less standard. They look at the convenience, as you say it as well, like how much harm is done. But if you have an IP right and there is an infringement, they'll give you the injunction. And it's a very quick process, actually, very efficient, and we like it for that reason.
Yeah, similar. And Dorothee, in Germany, I think we've kind of touched on this before, but it sounds like the position is fairly similar in Germany.
Yeah, I would say so. The position is quite similar, unless a defendant waives all rights at the end of the interim proceeding to opposition and so on, and really finalizes the case. There must be or there will be ordinary proceeding. It's readily available, the interim proceeding, in case of urgency, of course, but will be presumed in most cases if the if the claim is filed within 1 month, 1 month of notification, or if that the applicant has knowledge of all facts of the infringement. And on the other hand, of course, that the grounds of the injunction are made credible. There is maybe a little differentiation, as you said, to what you said, Maarten, with regard to the evidence, because in the interim proceeding, we will not hear witnesses, or witnesses may be heard, but at first only the evidence has to be made credible. And we have a lot of statutory declarations there, which might be totally different in an ordinary proceeding than when they are heard as witnesses, because as we all know, statutory declarations are usually being pre-formulated by some lawyers, or at least there are ideas which are given and certain wordings given, and if these witnesses then are summoned to be heard in an ordinary proceeding, things not seldomly turn out quite differently.
And I think, Maarten, you did touch on this, but and there's a similar, certainly a similar position in England, maybe less so in Scotland, that once an interim order is obtained, perhaps less so now, but certainly go back a few years, the position in England was that you would then be looking at what was called a speedy trial or an expedited trial, so that once you had your interim order, you did then have to accept that you're going to be preparing for a full-blown trial if there wasn't a resolution. Not as I say, not the position in Scotland, but that did tend to mean that in quite a lot of IP cases, they were pushed through the courts quite quickly to move to kind of substantive procedure. In terms of timing, if a case or a kind of an IP infringement case was being litigated in the Netherlands, if it moved beyond interim stage, or if it was on a kind of an expedited basis, what does that mean? You know, how long would you be looking at for a kind of an IP infringement case to run to its conclusion if the other side didn't negotiate a resolution at sort of interim order stage?
Yeah, perhaps if I take one step back, the interesting thing here is that we are in charge, basically, as the claimant is in charge about the litigation on the merits. So if you don't do it, it won't happen. So there's no way a court will like refer it to litigation on the merits. It's simply a separate thing. So either you ask for an injunction in summary proceedings and you follow that route, or you go to litigation on the merits, and that's separate and your decision as a claimant. So, and if you don't do it, you may suffer the consequences, but that's the exception. And if you, I would say the regular scenario would be to first ask your injunction and summary proceedings, and that will take you a couple of weeks for the whole process. So let's say 6 weeks. So you get your injunction, and that's just one hearing. You prepare your summons, you send it out, you go to the hearing. Basically, a hearing is like 2 hours. That will be very different, I think, from other countries. So it's very short, and then you get your decision within 2 weeks. So the whole process 6-8 weeks max, and it can be much shorter. It can be half a day if you have a real urgent matter, like my media colleagues have. They get a phone call and they go to court in 2 hours later. So that can happen as well. And then you have to think: what will we do? Will we negotiate settlement? Is there anything to fear from the infringer after the injunction was given? And if you want to proceed with your litigation on the merits, that's a separate thing. You prepare it. There's no time. Well, there is a fixed time frame in the decision, so it should be within 3 or 4 or 6 months, whatever is in the decision. You start that, and then you get into a much slower thing, unfortunately. And in the past, it used to be quite quick, like a year perhaps, to get to the decision, and now it's longer, unfortunately, because there's a lot of workloads at the courts. So,
and if you start that, even if it's going to take a long time, you will retain the benefit of your interim order because you have started those proceedings.
Yeah, exactly. So that will be in place. And then for patents, we do have a kind of expedited procedure, which is interesting because patent litigation is complex, as you know. And that's the one example where the court in The Hague, which is a specialized court, kind of created a quick litigation on the merits, which sets the dates pretty quick, and the timeline is quick, and that will get you through the process in I think 8 months or something.
Okay.
So that's fine. That's fine. But a regular litigation on the merits, I would guess like a year, and then you're lucky, and if you're unlucky, 2 years perhaps.
Yeah, no, that sounds makes sense. And Dorothee, in terms of German substantive German court proceedings can take a while.
Yeah, unfortunately, yes. We do have specialized IP courts though. Patent and trademarks, copyright chambers as well. So that is, of course, accelerating a little bit the cases, and also, of course, enhancing the quality of the procedures. But it takes a long time because of the backlog, and there is no special expedition of the cases.
And is there any kind of there's no requirement if you've obtained an interim order and you could have obtained that quite quickly, there's no requirement, or there's no expedition of any kind of trial hearing or anything like that following on from the grant of an interim order?
No, of course, if you are lucky and the judge will not be switched there, so you will come to the same chamber, and then you will have the same judge, which might always change because judges might be advanced or whatsoever. Then it might be a little bit quicker because the judge already knows the case and knows what they are talking about. But yeah, as usually there is no expedition of that.
No, thank you. And then Terrell,
so what's the timeline, Dorothee? Because you say very long, but is it like 2 years or 3 or?
Yeah, I would say unfortunately in the meantime it's at least 2 years, if not longer. Yeah, ordinary proceeding is incredibly long before you get even the first hearing. So it's a shame, unfortunately.
And Terrell, I mean, given that interim orders aren't as readily available, is there scope for expediting or pushing through your substantive trial more quickly in the States?
Outside of an injunction having been issued, no. So if you have an injunction issued, you can request a preferential trial setting, in which case the courts will try to give you a hard trial date, and they themselves will try not to move it. Because oftentimes what you face is courts will have to move their own trial date. If it's a federal court, they may also have a criminal docket, and criminal cases in the US are going to get preference over civil cases. So you might get bumped. But that goes a lot to why we have the form selection. I would actually say it's probably more of a problem than it is a benefit in the US, simply because the parties spend so much time and effort trying to pick the form they want to be in. And if a defendant is in the wrong form, or feels they're in the wrong form, or they're not the preferred form they'd like to be in, you may have substantive fights over the forum selection that could last 6 months or more before you ever even get to merits of the litigation. So in the US, really, you're looking at, I'd say on average, 2 years for a basic case to get to trial. And I only say that's on average. Really, it can be quite longer, but that's because there are some jurisdictions, particularly if you're in federal court, because the federal courts, unlike the state courts, federal courts have larger staffs. They have law clerks, so they have lawyers that work for the judges, more magistrate judges that can handle smaller discovery disputes. So in a federal court proceeding, some judges pride themselves on getting you to trial within 12 to 18 months. So that's where that forum selection fights come into play, because the plaintiff may want to be in a very quick forum and try to get to trial in the Eastern District of Texas very quickly, or a particular judge in the Western District of Texas that is known for really wanting patent and IP cases. So it all really kind of depends on the strategy, but all told, you're looking at a long time if you're in substantive merits litigation to get to a jury.
And if you don't have an interim, the benefit of an interim protection in the meantime, I mean, what does a party generally just carry on infringing, or does there tend to be a pause because of the risk, or is it just
it's really defendant specific. So I think obviously in a plaintiff's viewpoint, most plaintiffs would want the defendant to just voluntarily stop the alleged infringement. Most defendants don't if they're giving the position, we don't infringe for XYZ reasons, they want to show that they believe in their position, and they'll continue to sell the product or whatever it is that's causing the infringement. And, the courts, as I mentioned, they'll look at that and just say, doesn't matter. At the end of the day, that's damages. You'll get a check for it. Everybody will be made whole. So that's, again, why the courts don't issue injunctions in most situations in the US for IP matters.
Yeah, that's helpful. And I think conscious of time, but we're moving on to just very briefly then cost recovery. So when we get to the end of all of this, and I mean, the UK position generally at a pretty basic level is that costs follow success, and there are different models. So costs may follow success, but it's quite rare that you get full indemnity costs. You'll maybe get back a percentage, depending on where you are or what you've done. It could be anything from kind of 50 to 70% of your costs. But generally, if you succeed at the end of the day, you will recover an award of costs that will come at least relatively close, hopefully, to what it was you've actually spent. But in Germany, Dorothee, how does it work in terms of costs?
Well, it's totally different, as you might have experienced. Well, in general, we have the principle of success liability. We have a statute on attorneys' fees. And the statute on attorneys' fees is based on the value of the matter. The value of the matter is, of course, quite a discretionary term, and it will be fixed by the court. And in IP disputes, the value of the matter is usually quite high. So an ordinary trademark infringement would have maybe a value of the matter of 100,000 euro, even if the infringer says, I did sell only 10 products or whatsoever. So it does not matter what the infringer is doing, but trademarks are regarded as high, patents often even much higher. So, but 100,000 euro, it does not mean that you get 100,000 euro in fees, but this is only the basis for a calculation in the statute. And it results that the attorney's fees are rather low. So usually if you have a sophisticated legal advice, you will pay, as in most countries, an hourly fee. Yep. And this will usually exceed the costs which you are likely to be compensated once you you entirely win the case. That's the downside, that you will not get everything back. The upside is that if you lose, you have not to compensate to the defendant the entire costs they had. So it's a little bit, I think the concept is made because Germany said the legal court proceedings must be available also for small entities, for small enterprises, and not only for the big shots.
Makes sense. And Maarten, in the Netherlands, how does it work on costs?
We had a very interesting development a couple of years ago when we had the enforcement directive, European directive coming up, and I think only in the Netherlands the lawmakers, politicians.
Oh. just at the critical moment, Maarten froze. So
and there's no reason.
I think your screen froze just as you were coming into the critical bit about what the lawmakers decided to do.
Only in Holland, the law makers thought they had to adapt cost compensation in IP cases because the enforcement directive is about IP cases. So we have the specific circumstance that only IP lawyers like myself can claim more costs, much more, than any other type of lawyer in competition law or liability law or whatever you can think of. So we are in a kind of good position if you think you win the case, of course, because it's more risk than the other system, I would say that. But we can claim costs back, and the courts have adapted a kind of system where they attach a fee to the complexity of the case, which makes sense, I think. So if it's an easy case, it's much less. If it's complex, you can get even we had in a patent case like 200,000 euros back for a patent case or amounts like that. But a simple case will be like 6,000 euros up to 20 or 25, and it will never cover your complete cost. So I agree with Dorothee, it's always a percentage of your actual costs as a client. But it's interesting from a strategy point of view as well, because we often have the decision to make whether we will always want to say for the IP owner, it's an easy case, it's an infringement, it's completely clear. How can you not see that this is an infringement? And I always act for the IP owner. And then I say to the client, I would like to say this, but the consequence that we won't get a lot of our fees back. So that's
so, yeah, I can see that it's either complicated and you get your fees back, or it's straightforward and you get your order.
Yeah.
It's not a difficult choice, is it?
Yeah.
So yeah, and I think you touched on this earlier, but in terms of cost recovery in the US, certainly not automatic by any means.
Right. So it's available. Costs and attorney's fees are available for all IP disputes in the US. And it's typically by statute. And what those statutes do is they grant the courts the discretion to award attorney's fees and costs that are reasonable to the prevailing party. And there's typically has to be a finding of exceptional circumstances or willfulness, sometimes both, for a court to really kind of look at the totality of the circumstances and determine if one party's conduct was so egregious and abusive that the other party the prevailing party should be awarded their reasonable attorney's fees. At which point, if such a finding is made, the court will request the prevailing party to submit their request for attorney's fees and their bills, redacted billing statements and so forth for the court to then review. The court will make a reasonable determination as to what they believe should be awarded. And that's the process. The unfortunate part of it is courts are typically hesitant to award the fees. What they will normally do is just say, look, both parties are here, both parties fairly litigated, one side won, one side didn't. But as long as it appears to the court that the case was reasonably prosecuted and reasonably defended, they're just going to let the chips lie with each party bearing their own costs.
It's a different mindset, isn't it? It's just a fundamentally different mindset. I'm conscious we were supposed to finish. We've overrun by 10 minutes or so, so I think I probably should wrap things up before we kind of I don't want to take advantage of everybody's good nature as we kind of run up to kind of 5 o'clock, certainly UK time. And I've tried to pick up questions that came in as we were going. So I think probably it's really only for me now to thank you, Dorothee, Terrell, Maarten, for participating. If there's any other questions for those that are watching, please do just email them in and I can share them with the panel and we can come back to you. But no, thank you very much to the panelists. Thank you for everybody who dialed in, and enjoy what is left of your working day. Thank you all.
Thank you.
Thank you.
Thank you.
Pleasure.
Bye.